Okay, it's Tuesday, June 2nd. We'll call the meeting to order for the planning board. This is our video conference via Zoom. And again, I will read a statement that I have confirmed with town council that tonight's meeting has been convened in accordance with the governor's March 13, 2020 Executive Order 202.1, which I think has been updated as well, which suspends certain provisions of the open meetings law to allow a municipal board to convene a meeting via video conferencing. In accordance with the executive order, the public has been provided with the ability to view and hear tonight's meeting, and a transcript will be provided at a later date. I've done a roll call of the board members, and there is a quorum present for this meeting. I've also confirmed that this meeting has been duly noticed. A link has been provided to the public so that the public can view and participate in the meeting. Furthermore, a video of this meeting will be made available on Public Access TV and the town's website. As always, the agenda and all materials considered for tonight's meeting are available for viewing on the town's website. And we'll take it from there. I think we have a public meeting this evening, so we do have a mechanism for us to see members of the public trying to speak or talk with us through chat. So we'll try to watch for that in case we have comments. And we'll go to our first matter for this evening, and that is the Bukowski application. This is 23 Heathcote Drive, application for a lot line adjustment, 23 Heathcote Drive. And I apologize if I, again, butchered your name, the applicant's name.
Chakowski, but that was a pretty good job.
Okay, I may get it someday. Who knows? In any event, we discussed this application last time at some length, and I know we had a few comments from neighbors. I don't know if we've seen any further comments or anything in writing. I haven't seen anything further, but we had talked about this. We had an extensive memo from the environmental coordinator. There was some issue and some concern about wetlands in the back lot that is going to be merged with the front lot. I thought that Eldad at least brought me to my senses with his comment and reminding us that this was really just a lot line change and not an application for extensive activity in the rear lot. So with that, we directed staff to draw up a resolution. And it might be appropriate at this point. I don't think we've seen any changes to the application, so it might be appropriate at this point to run through the resolution. Now, during the course of the day, I contacted Sabrina, and I had some thoughts about the resolution because I thought it was deficient in that it did not reflect some of the concerns that we had last time. I think what we'd like to do, at least it was the sense at the last meeting, was we'd like to have a resolution put together, but we'd like to have some touchstones in the resolution to give staff, future boards, some notification regarding some potential concerns regarding the property. And so I made those two suggestions, and then Sabrina cleaned it up a little bit further, of course, during the course of the day, perhaps with guidance from more intelligent members of the board or staff, attorneys, and the whole clan. So, and I think ultimately what we'd like to do, I think, is to move forward on this, waive jurisdiction so that we can move this process along a little bit faster and close the, well, I guess, first of all, I need a motion to open the public hearing.
So moved.
Second?
Second.
All in favor?
Aye.
Aye.
Okay. I guess I'm supposed to do a roll call, but I think that was pretty unanimous there. So we'll go with that for there. We have our resolution. We have our thoughts. The two things that I was concerned with was that this is not an application for activity in the rear lot. Nonetheless, the environmental coordinator did express some concern that there were some indications of wetlands or wetland buffers in the rear lot. And I thought it was important to have a touchstone in the resolution to draw people's attention to those, and not to require the applicant to do anything further in terms of wetland studies, et cetera, but to defer that until such time as an application might be filed by the applicant for activities in that rear lot. The other issue we had was, this is a, I wasn't quite sure of the history of these lots that fall behind the lots that front on Heathcote, but they're oddly shaped. And although they're not flag lots, they start to take on some of the characteristics of flag lots. And there was some concern that the rear lot would go over and pass behind the lot of neighbors, of a neighbor, maybe two neighbors on either side. I'm not quite sure. So there was some concern about that, and I think the applicant agreed, and the applicant's representative agreed last time that any activities would be confined to those areas that are directly behind the front lot. So those are my thoughts, and I think that's what we have in terms of some of the redlining that Sabrina has prepared for us. So any thoughts, concerns, issues, please, from the applicant. We don't mean to just shut down the applicant if there are any thoughts or concerns. It was my understanding that based on, I guess, the representation we had from Jerry last time, that these were agreeable. The applicant would be agreeable to these. But if there are any concerns or issues, we should hear them now, I guess.
Thank you. First, thank you all. We did get a copy of the document this afternoon. So we didn't have a lot of time to review, but I can appreciate how much work that does go into it.
Did you get the red line copy?
Did not get the red line, so I don't know.
No, they got the final copy. They have the clean copy based on the red lines.
Okay. So you got the right version of it. Good.
Right.
They do. They have the right version.
Right. So look, I think largely, yeah, we are accomplishing what our means was to, or our goal was in merging the lots. I know that Dennis Corelli had spoken with some people about the environmental issues, and I don't think it's fully resolved yet, but there has been some update there, and getting the background on the lots of what it used to be. It used to be open sort of farmland, and that's a large part of the history of why it is the way it is. I think honestly the only concern we have with the existing language is sort of limiting any disturbances to the directly behind our house. We don't have, as you said, plans that we are presenting right now. And if we do, the plans that we have in our head that we may act on in the future would all be as close to our house and directly behind our house. So that is our intention. It felt like with the respect of the T-shaped lot, and we have great relationship with our neighbors, and we would never, we respect our privacy and their privacy. We would always want to be respectful of that. The way it's worded felt like it was a little bit too limiting for a lot of that size to limit it to just that area. So that was really our main comment, and I could highlight what sections that's in if it's helpful.
Please do.
So basically 16 is page 4, number 16, I think was the main part of it.
Sabrina, I just want to make sure I didn't have a chance to follow up on everything, but you got my 2 comments on this?
I did. They're reflected in the draft that you're looking at. If you're looking at the clean copy that was sent out later this afternoon, that incorporates all the changes I received up until sending that document, which did include your changes, Dick.
Thank you.
Well, in response to the applicant, I think the language, actually, the way we've drawn it here is a little too tight. My understanding is that we were not concerned that it would be directly behind the applicant's house, but that it would be directly behind the property lines of the front lot. I think that is too much of a burden on an applicant that has to be directly behind the house. So
The
we have
way-
an eastern, I think it's an eastern and western property line of the front lot. So my idea would be that it would be any activity would be basically limited to the behind the property lines of the front lot. Again, avoiding any kind of disturbance behind the neighbor's property.
Mr. Chairman, if you look at one of the earlier whereas where it's first mentioned, I think it's written that way, the way you meant it to be written.
Yeah,
It's one of the earlier whereases.
Right.
Looks
right.
like page 2.
Yes, line 2, exactly. So, and there are a couple of changes even there I'd make, not solely, but directly behind the tax parcel. Exactly right. So I think you're right. And I would, again, to add clarity, I might add not just behind the tax parcel, but behind, the eastern and western property lines of the tax parcel. Again, I think that's fair because then, that's just a rear lot and the space resembles just a larger, oversized, rectangular lot without any kind of backing behind the neighbor. I think our
If I may suggest the following language, if I can suggest the following language, and then Mr. and Mrs. Bachowski, if you could tell us whether or not you're comfortable with it. Rather than it saying directly behind the house, the clause now says if the applicant is to make application for a building permit, all disturbance shall be reflected on the plans to be located between the eastern and western property lines of tax parcel number 3093.5-1-7. So that way it is if you were to draw your eastern and western property line today on the lot where your house sits straight back, you have that area within which to develop your accessory use.
Do we have grading and clearing limit lines here?
We have not established
Just
clearing and grading
parcel.
limit lines on the vacant parcel.
What about on the smaller parcel?
I'm sure that there were established clearing and grading limit lines
Okay.
when you
so that-
approved that lot.
Well, then I would suggest that we can do everything that is in the smaller lot, save not encroaching into the clearing and grading limit lines.
Wait a minute.
The other issue I would say is I don't think we should limit it to just building permits because after all, we could have a tree permit, for clearing of trees, and I think that would be of paramount importance to the neighbor. So any sort of
When
permit,
you
building or otherwise.
A building permit, when you make an application for a building permit, it triggers all of the other what we call sub-permits, a tree permit, a wetlands permit. It all falls under a building permit.
Well, I have
What
a
if they were going
question.
for just a tree permit? They just wanted to clear trees. And that's what I'm saying.
They'd still have to submit a building permit.
I
To
have
clear
a
trees?
question that,
Oh, okay.
It's a category of permits.
Okay.
hello, can anybody hear me?
Yes. Hi,
Yes, Tom, we can hear you.
I have a question. I think that Dick raises a pretty good point. So could somebody confirm, I don't have the drawings in front of me. Could somebody confirm that there are, I think Sabrina just said that there are clearing and grading limit lines on the existing parcel, the one that has.
I would, yeah, I would defer. Peter, are there, I'm not sure of when this initial house was built. Can you clarify that, Peter?
I think a lot of the disturbance that was created to construct the home at the primary lot on 23 Heathcote extends right to the property lines. There was landscaping that was installed along the property line, and the rear property line basically was the septic system, the extent of the septic. So for the most part, the entire 1 acre parcel was disturbed as part of the construction of that home.
But that's not the question I'm asking. What was built is not really the question here. Are there clearing and grading limit lines established as part of the original subdivision approval or the building permit approval when this that exists now on the property?
9-1.
I'm not entirely sure of that, but I do know that, as I mentioned, that what was involved to get the septic system in would have required going to the rear property line. But I
So
do
Sabrina,
just specifically for the subdivision parcel.
okay, understood. So
Process.
Sabrina, do we know that the documentation we have for the existing, the parcel, the front parcel, the documentation is accurate with respect to all of the restrictions that apply, development restrictions apply to that property?
I'm not sure I understand. I can tell you that this may not have had a clearing and grading limit line because it may not have been subject to the planning board review when the house was constructed.
That's fair, but don't we need to know that? I mean,
Well,
it seems
I
to
don't
me that we
know.
need, that we,
There's
I
another
think-
way, Tom, when you finish.
I think that we need to know that, and the reason that we need to know that, I think, is just because you vacate a property line and increase the size of the property on which there is an established grading and clearing limit line does not mean that those clearing and grading limit lines just all of a sudden disappear. They should still apply to the larger property.
Well, I have another thought here. If you do get the drawing, it's a preliminary plat, and it has a 35-foot side yard setback. And I would say that that no structures should be built that are not in accordance with the setbacks. Just to make it
Well,
clear.
that is zoning conformance.
I know.
that is zoning
just to make it
conformance.
clear for the applicant.
I think that we're kind of falling back into that trap again of trying to regulate something that's not even being asked. Again, to go back to the concept from the last time, which was the request is to eliminate the tax lot line. Correct me if I'm wrong again, because I'm new. I definitely can be wrong, but any activity that the Bachkowskis undertake or would like to undertake here, that has to come before us, right? And any kind of disturbance of the land.
No.
No,
No,
Not
unlikely,
necessarily.
actually.
No.
Anything that requires a building permit that has some problems with the setbacks, that would be a problem that might go to the zoning board of appeals. But,
Peter, Peter, can I ask you to share your screen with the plat map on it so the board can
Yes.
see the setback lines?
Sure, let me try and do that for you.
Can I say
I think
one
that
thing
would
here,
help your
guys?
conversation to see it. Yes, please, Bob.
Sabrina, yeah, I agree with Sabrina. This lot was not part of the Heathcote subdivision lot. So because of that reason, it really never had any clearing and grading limit lines to begin with.
okay.
It was an out parcel part of the subdivision. So it was never something looked at by the planning board when Heathcote came in. And the lot just to the west was part of the planning board subdivision, which had clearing and grading, but this lot does not. Just to answer the question, that's kind of what Sabrina said before.
Right, and so I just wanted to point this, the dot dash, the long dash, little dash line that goes around both properties, that is the setback line. I think I'm going to draw on here so you guys can understand, and the Bachkowskis can understand what you guys have been talking about is to limit disturbance like that. Can everybody see the lines that I made?
Yep.
Yes,
Very
beautiful.
attractive.
Beautiful color.
Very helpful. Well done.
I aim to please. So that's what we're talking about. And if you look, here is the zoning line. Here.
That's correct.
And so what I would like to do, I don't know if the neighbors are attending the public hearing, but maybe, Mr. Chairman, you would like to open this up to see if the public has comments about this concept before you further discuss it.
Sure. Are there any comments from the public? Are there anything in the chat? I think we see things that appear in the chat, right?
Yes, if you look at the participants, there are several participants watching this meeting, and I think that you should give them an opportunity to write in comments if they have any. And by all means, I would encourage you to continue your discussion regarding this matter, but at least give them an opportunity to start writing their comments if
Sure.
they have any thoughts about this.
Yeah.
Well, while we wait for their comments on this, I'd like to go back to the clearing and grading limit lines. So it's good to know that there are none that that are in place in the existing subdivision that was made. I don't know when, but now what we're doing is this is before the planning board, and the planning board has the authority and responsibility to look at this lot with respect to the sorts of things that we worry about. And I don't think that we're going to be suggesting any clearing and grading limit lines that might apply to the lot that has the house on it. But to the expanded lot, it seems to me that maybe we ought to be thinking about what is appropriate there. If we don't, then it seems to me that what we're doing is giving the applicant carte blanche to clear the whole property, unless I'm wrong. I'm happy to be wrong about this. Clear that whole part of the lot for whatever purposes he chooses.
Well, I don't know. Did you miss the very beginning of our conversation on this, Tom? You were a little bit late.
Yes, I was.
So, yeah. So I had voiced our opinion, my opinion, and my recollection that we had talked about this last time, and our concern was exactly that, Tom, and that was one of the reasons why we were looking at limiting any kind of future activity. Not that there was that we're looking at it right now, but just so that there was a touchstone in the resolution for the building department or future boards, that there were some issues and concerns, and that we were not going to require the applicant to complete a wetland study at this point because there's nothing proposed, but be aware that there were some issues. The environmental coordinator had noted some issues and concerns that he felt could trigger the need for a wetland permit. And aside from that, we heard from a neighbor or two last time about disturbing property directly behind the property. Now, I understand that we've heard from the applicant, look, I have certain expectations. So I bought the property, the real estate brokers made representations. This is why we bought it. But also people who live there also have expectations. And it was not clear to me what the history of those rear lots was. And, clearing that property behind other owners, other neighbors, as we heard from at least one neighbor last time, could have an impact on the enjoyment of their property.
No, I do remember. I do remember that conversation
Yeah.
from last time, and I understand that that's the intent of the way that I think that that's the intent of the way the resolution is written. But I'm talking about something else. I'm talking about. Does that mean that we are releasing any concerns about the property which is within the purple lines here? That the applicant is free to go ahead and do whatever the applicant wants all the way up to all the way up to the back property line, regardless of
to the extent
such
that
as buffering, regardless of such issues as buffering and all of those other things.
Well, I would say yes.
If I can point out,
free to do that unless
if I can,
a trigger. Go ahead,
if I can, if you look at the green outline I drew on the plat map, those are the zoning setback lines. There is nothing that he can do beyond those lines right now.
Yes,
I think it might be important for
Sabrina, I'm sorry to interrupt, but yes, he can. He just can't build back there. but he can go ahead and clear.
Correct. He can't build back there.
But he can
Correct.
clear.
Thank you for correcting me. He can clear it. It
Thank you.
will require a permit from the town offices. I think it might be important. I know that Dennis Corelli, the environmental coordinator, had done further investigation based on the last meeting. Dennis, would you like to share your findings from that meeting to today? I think the board would want to hear that.
Okay. Can you hear me?
Yes.
Yep.
Yes.
Okay. So I met the Thursday before Memorial Day weekend. I met with Steve Coleman, who's representing Dr. Singh. It's the only reason why I'm mentioning his name. And I guess Paul Janning, who represents the Bachoskis, who met me on site so we could walk the property. Paul Janning handed me a report that I thought was a duplicate of the wetland report that I included in my prior memo. And it sort of was, but it was actually the original report that was done for, I think it was a Mrs. O'Neill, and it was from 2014. And that included observations and investigations from July. I remember reading that in the report. And the soil borings that were taken, I believe, were just carried forward to the 2016 report for Tavalachi and Dr. Singh's property, which of course covers those two back lots. That's why I'm mentioning that particular report. And that was the report that Steve Coleman in 2016 issued, the memo that said that the areas would not have been regulated by the town as wetlands because under normal conditions, they didn't contain hydrophytic vegetation, wetland hydrology. They did obviously have hydric soils from the soil borings. So to that point, we had two reports. One where observations were taken in July, the other where observations were taken in September. There was no hydrology. So the problem, as I explained to them, is that when I went out there in the absence of those reports, I was out there on March 31st, and I was out there again on May 7th. And I said, you had, positive indicators of hydrology to the level of that the sinkholes that form in that center spine were filled to the surface with water. And I said, I'm not convinced it was all surface water. I just feel that there's a raised water table element there. And on the Thursday before Memorial Day weekend, when I walked there with Steve and Paul Janning, those sinkholes were dry. So in my opinion, moving forward, I wouldn't expect to see, unless some precipitation event, that you would have that hydrology. So now our discussion kind of turned back to 2016, and Steve and Paul were saying that, the way the town defines wetlands in Chapter 137 states that under normal conditions, you need hydrophytic vegetation, wetland hydrology, and hydric soils. Within the definition, there's also mention of a particular manual. That's from 1989, and that's the federal manual, as we call it to shorten the term. And I said, I agree that the definition would meet that, but I said in this manual, there are procedures that would lead one to call the area wetland, specifically not under normal conditions because of the situation that we have. And I think I had mentioned last time that one would be considered a disturbed condition and the other would be considered a problem area. And the disturbed condition has to do more of a man-made anthropogenic influence, I would say. So in this case, and it was very historical, according to Paul Janning, that there were attempts made, obviously, to remove hydrology on the property. And according to Paul, that goes back to probably the 40s from his review of aerial photos. I didn't substantiate that, but I don't doubt him either. And that federal manual really only focuses on, and Steve and I had this conversation and we agreed on quote unquote recent disturbances. So attempts made to try to remove hydrology so that you try to dupe regulators, dupe whoever that, there's not a wetland here because you're not meeting all three parameters. So I would definitely walk back from my assessment with respect to a disturbed condition. As far as problem area, I think there is a bit of an issue because obviously hydrology is very ephemeral on this site, and whoever put in the attempts to try to totally drain the property for all 12 months of the year, I guess it doesn't happen. So the question then became to Steve was, well, I said, then this is like a kind of a two-part question for me. I said, we obviously can find a methodology in the federal manual where we can call this area a wetland because we don't necessarily have all three parameters, but it specifically has methodologies that allow you to still call something a quote unquote wetland from sort of an ecological classification purpose, not a regulatory purpose, just an ecological classification purpose. So he agreed because he kept using the language, which I agree with, to our general code. Right, I said it wasn't a wetland because under normal conditions, it wouldn't be a wetland, and it specifically says in our code under normal conditions. And I said, right. So I said, having said that, the similarities would be then, as the Corps of Engineers has under the Clean Water Act, you could have areas that are considered wetlands as far as an ecological classification, but the Corps doesn't take jurisdiction. We know from New York State DEC, for whatever reason, the majority of wetlands that they map and take jurisdiction over are 12.4 acres or greater in size. Don't ask me why, like just the way it's always been. So you could have a 10-acre area that meets New York State DEC's criteria for calling something a wetland ecologically, but they wouldn't take jurisdiction. So now it comes to this particular property where I think ecologically, according to one of the particular methodologies that is in the federal manual, you would call something a wetland. But the way it's written in chapter 137, it would possibly not fall under the jurisdiction of the town because it's not normal conditions, because it doesn't contain hydrophytic vegetation, wetland hydrology, and hydric soils. It contains only two of those three. So having said that, whether something is a wetland or not, from the perspective of a regulation, I would only, going forward, and I don't have experience in this area, is that something that would need consideration if someone were to propose to do something whereby, well, it's not a wetland, but what you're proposing, we're concerned with the hydrology because, and whatever those conditions may be, we're concerned because there's still hydric soils, which indicates that there's water. Again, not a wetland, but is that, so at this point, that was just a discussion after a meeting, and I believe Steve definitely, which I've yet to receive, was going to issue an assessment based on our visit and an update. So I haven't had a chance to review that because I haven't received it. And I didn't know if Paul Janning was going to submit anything subsequently either. So at this point, that's just a verbal assessment of where I felt we left off, and haven't
Dennis,
really.
a question for you and probably Dick. How do we define normal conditions? Is that over a 365-year normal test? Is it what we normally see in springtime? Is it what we normally see in wintertime? Is it what we normally see in August? What does that mean?
Dennis, I'll let you go first.
Sure. I believe the way the manual was written, that normal as it applies means that under normal conditions throughout, right, a good percentage of the year, that you will have all three of those criteria and you won't be missing something because of a seasonal component or based on, let's say, the biology of certain plants. So the examples that they use are, you know, especially with the hydrology, some of these, you know, ephemeral areas that, you know, during, like, let's say springtime, you know, you have your hydrology, but, you know, for the rest of the year, you're like, wow, everything's bone dry. Or in the case of things that are classified as like vegetated flats, some, you know, that vegetation is not necessarily pervasive, nor are you going to see evidence or remnants of it after it's sort of gone through its growth bloom period and now it's gone. So in some cases, something, may not be classified as a wetland because it's like, oh, it's just open water. There's no vegetation here. So that's kind of how it gets applied with respect to how I'm looking at it for this particular property. The other normal or lacking normal goes down the road of somebody went out with a bulldozer and tried to eliminate all the trees, or, put a ton of fill on top of an existing substrate so that you now have a thicker layer that, you go down 2 feet and you're like, yeah, there's no hydric soils here. Yeah, because you just put 3 feet of fill over them, so that's not, we're not going down that road. So it's almost like a dual branch from a main point.
Dennis, unless I'm mistaken, you're still waiting to come to a definitive conclusion. You need a little bit more time?
I think that it's, I think in conversation with Sabrina and Bob, when we first discussed this and they asked the question, so is it or isn't it a wetland? I said, I don't know if I could answer that as a single word rubber stamp that applies to everything as I'm reviewing it.
Fair enough. So in any event, unless I'm mistaken, in any event, and I think that this goes back to Eldad's point, was that do we need an answer on that question now? Because there is nothing which actually is being proposed for development right now on this piece of property. And we can move ahead, and when the wetland information comes in, whether there isn't or there is, or the quality and character of it gets established, then that will get applied to any future actions that the applicant may want to put on the property.
Yeah, I think that's a very good start to it all, and it's very logical. I think maybe we can even go a little farther in that, as I recollect, I'm moving my arrow here. I don't know if everybody, can you see it?
No.
No, I can see it. So that's, that's unfortunate. But if you take the two pink purple lines that Sabrina has drawn, I would suggest, that those be the lines upon, within which some development can occur. And that would be reduced by the setbacks, the side yard setbacks, so that the applicant can understand where things can be built. The applicant has another set of issues in that the septic field covers a lot of the rear yard that might be reasonably dry. The other thing, I can see someone else's out. Yes, very good, thank you. Yeah, so that's a problem. You can't build any real structure on top of that. You can.
That's correct.
I'm not sure what you can build there, but maybe you can have some lightweight things that are play toys or whatever, like this play area that's over to the left a little bit. As I recollect, if you just go straight up to the top line, yeah, that area, that elevation of the land is about 2 feet higher than the ends of the side wings, the ones that they're going the long way. And so there's not going to be a lot that can be built back there in the way of structures. If you're going to have a soil condition that for 3 or 4 months the water is very high, and you're going to try and build something in that without fill, I think that would be another constraint. No fill. Don't bring no fill. It's because it'll change things. So I think we can move forward in a way and saying, well, no fill, without a permit and without a review by the planning board.
Wait, aren't we going too far? I mean, again, the applicant's here for a lot line. We've got in the resolution things that say if they want to come back and do anything, they have to come back. We can change building permit to anything. But I think to start restricting areas and putting pink lines and green lines, I think we're unfairly putting restrictions on this lot when the applicant hasn't asked to do anything on the lot.
Yes, but neighbors have.
Yeah, but no, but you know what though? The neighbors are just worried that something may happen. The applicant hasn't proposed anything. And I do think we are waiting for people to get back to us on, I thought there was deed restrictions that people were throwing out at the last meeting. That
We do
was
have some
somebody going to get back
comments.
to us on the deed restrictions on this property?
We have some comments from the public. We have two neighbors apparently who have commented. One of which is Ed Phillips, another is Michael Sirignano. And one does deal, I think, with some restrictions in terms of building lots from Mr. Rodriguez's attorney. So I don't know if those really resolve it. I agree
Well,
with
I
you, Greg,
think
to the
that maybe you
extent-
should let Clinton speak.
I am preparing, from the last meeting, I'm preparing a memorandum for saying on the issue of deed restrictions and covenants. And it's no secret that at this point, I do not see anything that would inhibit the authority of the planning board from either the covenant or the deed restriction. So you are basically free to act as you choose on this lot.
Okay. That gets to Greg.
Thank you.
Pardon me?
Mr. Chairman, I just have a question. If there's a concern that there aren't any clearing or grading limit lines being represented on this map, would it be amenable to the board if we were willing in the resolution to reflect that dark green line that's wrapping around to be an area to remain as a buffer following those zoning setback lines? And it could be as just language in the resolution that this area would be the overall clearing and grading limit, while we're not proposing anything that we really would go beyond that, as we would be looking to work in the, to the rear of the property anyway.
Personally, from my standpoint, I would not go along with that. And the reason I would not go along with it is my observation on this from the last time is that even though we're not going to call this a flag lot, it has some characteristics of a flag lot. We don't like flag lots. And the reason we don't like flag lots is they impact neighbors.
Mhm.
So that's the problem here. So my personally feel is I agree with Greg and Eldad that we should not at this point place any restrictions whatsoever in that area between the pink lines and of course the green line in the back. That's up to the future. If the applicant wishes to apply for it, they deal with it at that point. But I think it's important for the things that matter to us to put restrictions on what the area is that can be impacted, because it will impact neighbors. We're hearing from that again. We're seeing comments from the public on this again. And I think it's quite reasonable. There's a reasonable expectation on the part of the applicant's neighbors to not have this developed. Again, because it is something we would never, ever approve as a subdivision if this was going to be a building lot.
So
When you
Bob,
say-
Bob,
When you say developed, Bob, you mean structures as opposed to grass or
Yes,
You know,
yes, exactly.
planted area.
so Bob,
Any kind of activity that's going to have a structure, that's correct there. But
How
more
about
than
though
that,
if they want to come in and cut? Say they want to
I-
cut, if they want to come in and clear to put in a soccer pitch, that would,
Mhm.
I would think would need, so it can't just be structures. I think it has to be in action.
any activity.
Okay.
I think we speak in terms of activity in all our regulations. So that's why I was asking about the permit before building permit, because I think, again, Greg, I think you're correct. A tree clearing permit, if that can be obtained independently of a building permit, I would be concerned with that. And I think that should be something that should be looked at and triggered or restricted to those, the areas in the purple lines. Look, they bought this lot, it's their property, they should have the enjoyment of the property to the extent that it does not unfairly, unreasonably impact the expectations of neighbors.
So can I just
Sure.
make a couple points here, if I may? I understand that, I completely agree, Bob, with you about the question of, and actually I think it's an issue, not just a question, of the potential for developing behind the adjacent neighbor's property, their lots. I think that that's would be an impact to the quality of the neighborhood overall, and I think it would impact their property values. And I think that there are actually some comments that we're getting in that regard. But that notwithstanding, there is still the question of the area between the two pink lines. And to me, that doesn't, just because we are suggesting that the areas which are to the left and right of that, we are going to be putting restrictions on, that the area between the pink lines is an area that the applicant, that the homeowner, is free to go ahead and clear. Now, I understand that there are in entirety, because we're putting no restrictions on it, other than a tree permit. Are we putting no restrictions in that area? I mean, what if the applicant has already suggested that the reason they want to do this is to get a clear area where they can have a place for their family to enjoy? And I understand that. I have no problem with that. But this would be the first time, I think, that we would be so, I don't want to say cavalier, but inattentive to issues that actually clearing and grading issues that pertain on a whole acre of property that goes all the way to the back property line and abuts a neighbor's property.
Well, but if they need a tree permit, which would come back to us, they would have to come back to us and explain why they had to have something back there that's a structure, particularly with soils that to the left and the right of the pink lines, I believe are much wetter, longer during the year, but still perhaps not, a wetland. But it makes construction hard. But we would, I think, retain suzerainty over anything that happens back there.
So
clearing, chopping down trees, trying to change the terrain, whatever.
So Dick, if I understand you, you're suggesting that if they come in for a tree permit, which what they would have to do to clear it, that would open the door for us to then address the larger question of grading and clearing, and the potential for requiring putting in a buffer, for example, on the back property line. Does that open the door for us to take those actions if we have not put in clearing and grading limit lines prior to that as a part of this application?
Well, if they take down trees, remember, we didn't have tree permits 15 years ago. So tree permits now bring it back to us, I believe. Right, Bob?
Well, I know they do.
It depends on how many. I think some will just go to the environmental coordinator. I personally, I don't have a problem with those activities in those lines behind the house and within those purple lines, provided whatever the activity is doesn't trigger the need for an application, which case, if it does, it does. They'd have to go see the building department, the environmental coordinator, or us, or zoning, or whatever. I mean,
the environmental review board.
Right.
Yeah.
To your question, Tom, I don't have a problem with an applicant clearing that in the back there, provided it's not a wetland, and making it grass or a play area. As long as they stay within those lines and within the setback, I think that's a reasonable use of the property.
Wait, hang on just a second. You mean
Sure.
within the setback?
No, not
Within
in
those
setback.
two purple lines.
Well, that's right. You said within the setback, the back property line setback?
Oh, no, the setback.
Except where the green line trumps it.
The dark green, yeah. They can't do anything. I mean, no one can do anything beyond the zoning setbacks. So whatever that is, what's that, Sabrina, is that 50 feet in the back?
30, well.
They could
It's
clear.
50
They
feet.
can clear. Bob, they can clear back there. Zoning doesn't say that they can't clear.
Well, clearing.
They just can't put a building back there or a
I know they can't.
structure.
I know they can't put a building back there. That's not what we're talking about right now. That's not what I'm talking about. I'm talking about the potential eventuality of a homeowner here, because there are no clearing and grading limit lines between those two pink lines, can go ahead and clear all the way back to the back property line, the property line that abuts somebody else's property.
No, back to the setback from the back property line.
Where does it say that?
We can add it.
Well, that's what I'm asking.
Yeah,
Well,
I agree with that.
Okay,
If-
thank you.
If someone wanted to go beyond the pink line in the future. If someone wanted to cross the pink line or go into that buffer for clearing, could they then come before the board to discuss what that project would entail?
You mean
I would think
left
so.
or
Clinton,
right?
that's an answer, question for you, I guess, Clinton. I would think so.
Uh,
It would be an application because it would be something changing this resolution.
Right.
It would be, it's also changing the security that you are implementing for the neighbors. So I would say that no activity in that area without application to the planning board.
Mhm.
Right.
So you would have an opportunity to review what those impacts would be in the future.
Yes.
Mhm.
Well, certainly to the left and the right of the pink lines.
Yes.
But we also want to make sure that within the two pink lines, save where there's a setback from zoning, that anything that goes on there, we would want to have some say. If they're able to, to refurbish an area that has no trees and make it into a grassed area where the kids can play soccer or whatever, I have no problem with that. But if they have to chop trees down, then there's a tree permit most likely that's going to be required, and that would come back to us.
Well,
Yeah, which is fine.
It may not come back to you.
it
Not
may not.
What do you mean may not?
It may go to the environmental
It may
coordinator.
go to a different board, or it may be reviewed by the stay with the environmental coordinator.
Look, I personally have no problem with the applicant because we already have provisions in our code when we have these sister and brother boards that watch out for these things and do a pretty good job, I think, such as conservation and people who look at these things. Also, I have no problem with those agencies dealing with, if they want to come in and clear some trees, it not coming to us. There is a system and people in place to deal with that. What I am concerned about, though, is that we have, I think, an obligation to be sure that we are protecting the adjacent property owners in what we do. And companion to, as part of protecting the property owners to the right and left of where this house is, with respect to development behind their property, I also think that we have a responsibility to be careful about and to be concerned about the people who are behind this lot. And that's why I think that it could be, I don't know what it should be, but for convenience purposes, if we want to say that that back property line, that back setback, which is the green line that stretches between the two pink lines back there, that green area back there is that line right there is a clearing and grading limit line. And if there's any activity that wants to go beyond that, they need to come to the planning board. Then that's what I think we ought to do. I don't think it necessarily has to be that deep. We could come up with a different line. And it's a little bit odd for us to be doing this over a plat map, when in fact, typically we do these things over topography and vegetation, where we really understand what we're dealing with here. But if we're in a place right now to make a decision right now, I think that we ought to be sure that we're protecting the property behind, and we ought to take that green line and say that's a clearing and grading limit line and just go from there.
Well, let me see, maybe there's another thing, maybe a codicil that says that any activity in, lot 7, which results in any kind of desire to change the vegetation, increase the vegetation, have a structure with pylons, or whatever, that should come back before us. Make it simple.
Why make up that language? We already have language that we rely on in the clearing and grading limit line. Let's just establish that line.
Yeah, I agree with Tom. I think if we just put the line in where we feel it's appropriate.
But how can we put in a clearing and grading limit line if we don't have clear information on what the status of the vegetation is, where it is and what it is? I don't understand how we do that.
Well, myself personally, I'm okay. I've been out to the lot. I don't think it's that high in nature in terms of trees, et cetera, but I may be wrong on that. But from my standpoint, if the neighbors, if the applicant wants to develop that area of lot 7 that we are limiting them to develop subject to our environmental laws and rules, I don't think we should be getting involved in the business of saying, well, you can't take down these 6 trees. You can't have a lawn if that's what you want for your kids, or perhaps later on, I don't know, if they want to put a pool in. You know, they have a limited property, as you noted before, Dick. There's nothing they can do in the front with a pool. They can't put a pool in the rear because there's a septic system there. It seems to me that that would be a reasonable use of their property that they've bought and owned, subject to our rules and regulations on environmental issues. If it turns out that that's a wetland, there's going to be additional problems and issues. I don't think there are any steep slopes here, but if it turns out there's steep slopes, that's another issue.
There are no steep slopes.
Yeah,
I can assure you of that.
Right, exactly. So, and I think Tom makes a very good point that we should make clearing grading limit lines to the rear. If we're uncomfortable, you know, if you want to be a little bit more conservative and draw it in a little bit further in terms of restrictions and have the applicant come back if they ever do apply for something, I guess that's okay. But my primary concern was, and I think Tom has raised a good point, there are neighbors in the back and we have to be concerned with them as well. Again, expectations, what these lots were supposed to be.
So there's something else in defense of, I think, everything that we're talking about here, which is that the addition of this very large lot behind the existing lot and making it, combining them into a very big lot really becomes an anomaly in the neighborhood. And it becomes the potential for development, a level of development, a scale of development, which is out of character with the neighborhood. And I think that those things are important to understand and important to take into account. And so I think that not only for the sake of the protection of, or the concerns of the abutters on either side, I think it's also a concern for the overall character of the neighborhood to think that we're going to be, we might allow, or one might come in in all of these lots, because there are lots left and right, as we know, to come in and to begin to go into the woods and take the woods out and begin to redevelop. So I think we're doing the right thing here. And I think that there are sufficient reasons to support it.
Sabrina, we have a question from a neighbor. And the neighbor's question is that they were under the impression that this was not a building lot and what could be built on lot number, well, I guess they refer to as lot 8, but I think it's lot 7.
This is lot 7, and
yeah.
This is the lot that's in the back of the primary lot is known as lot 7. This was Clinton needing to review that, and he is reviewing it first thing, and he's going to provide you with a memo. There are to be no structures behind on lot 8. That's what that information said, but the question is whether or not it's valid in regards to decisions you need to make.
That's correct. I believe there were 2 prohibitions. One was against further subdivision. One was a prohibition, a covenant against further subdivision. And that does not involve construction. The other was a deed restriction which limited one one residential structure per lot. The town is not a party to the deed restriction. So the town cannot enforce that covenant. That is private between the property owner of this lot and his neighbors. The town can enforce the prohibition against no further subdivision, but that is no further subdivision, and the principle of this application is one of lot merger as opposed to subdivision. Although it is called a subdivision in the state regulations and the town code, in my view, it's not prohibited by the no further subdivision language. And then the other not a building lot, that's a note on the survey. And those notes, if they are to be given content, must revert back to the resolutions, covenants, whatever that underlie them.
Okay. I hope that helps member of the public who wrote that question. If not, please feel free to send us another chat item. We have two comments from Mr. Phillips, and I think those are more or less consistent with what we've been talking about with the purple lines. So I think we have been talking about his concerns in terms of his property. I'm not quite sure which his property is, one either to the left or right of the subject property, but clearly one of the ones where property, yeah, okay, that one, thank you. Okay.
So, Mr. Chairman, do you want to go back to the resolution?
Yeah, yes. So we can tighten this up and move on then. Let's see what we can do with this. Do we have, to Tom's point, do we have any reference to clearing and grading limits in here as a whereas or a conclusion?
No, we do not.
So I think that that is something that we would want to include.
Hi, this is the applicant. Sorry, that's really hard to hear. I know that you guys are doing your job and trying to protect the neighborhood and the neighbors and whatnot. But you know, without any plans to do any of the major clearing or anything, it's you know. But I know you have to do that up front. Can you just give us a little bit of background on what you're talking about with respect to grading? And I'm not familiar with that. And again, I don't understand. I would. The town does have clearly defined plans and processes, and you know, by merging these lots, you know, coming in between the pink lines to follow all of the processes that would be in place, feels like it's that there are those checks and balances in place for that reason. But you know, just to help us understand what the context of that is would be helpful.
Sure. Sabrina, would you like to take a stab at that?
Sure. Right now, the planning board is determining whether or not they want to establish what's known as a clearing and grading limit line on your back lot, which means it would be a line drawn. We can use the shaded green area as an example, whereby you could not disturb earth or clear beyond that point. So you could not go into the green area. So they're looking at demarcating the back of your lot with a clearing and grading limit line. That means when you go to plan your accessory use, you would not be able to go into the area beyond that line.
Got it. Understood.
You also,
Okay.
it's not just, let's be clear about this, not just putting in an accessory use. You literally cannot clear or regrade back there. You cannot take out vegetation. I mean, there are certain restrictions that apply to that area. It doesn't mean you can't walk back there and enjoy the property.
Sure. Okay.
But you can't.
And we'd be able to
can't
put
go
a
any
fence in if there was a fence or something, you could do that. But again, no plans. I'm just asking what the.
And
what-
this
what that
isn't, and this isn't specific to you guys. This is all properties this happens with.
Okay, got it.
Clearing and grading limit lines.
And
Okay. And if the applicant on the other side of that came to do something, you would look at that the same way. You would put a similar line on their side to protect our property.
Yes.
Right.
typically, and it doesn't have to be a fence. In many cases, we put in like stone markers, that are kind of like flat with the land surface. So if your
Yeah.
child trips, they won't trip on a flat one, but it'll give you a sense as to where you have to keep the lawnmower, away on the good side of the stones.
Got it.
I would also like to suggest, just because of the nature of the way in which we're doing it, which is this particular clearing and grading limit line, it seems to me that if the planning board would be, if you wanted to come in at some point with a proposal for how you want to develop the property or clear the property that goes beyond that line, I think that the planning board would welcome that argument to see if there are reasons why this line was maybe drawn too arbitrarily at this point.
Yeah.
And further to that,
Has the board
I was gonna say, further to-
selected the line?
No.
no, I don't think we have, but I think in further to Tom's comment, if there is some sort of proposed activity and the clearing and grading limit line needs to be changed, what very often happens is there are other strategies that we can implement to enhance buffers, enhance vegetative buffers, etc. So that's why it's subject to permit, subject to an application. It's very difficult. We're trying to make sure that we don't have a problem with neighbors at this point, and you're not even applying for anything. So it's a little bit different, but that's because of the nature, frankly, from my standpoint, the nature of the lot, the dimensions of the lot.
Right.
Because if we don't do this, it in my opinion, could have an adverse impact on neighbors. By the same token, it's your property. In my view, it's your property. You should have the ability to enjoy it to the extent it does not impact others.
Great. Thank you for recognizing that too.
So what's the feeling in terms of, I think we should put some clearing and grading limit lines on here. I think Tom and Dick have made some very good cogent arguments on that issue. What do we want to do? Do we want to use the pink lines and the rear green line as the tentative clearing and grading limit lines? Do you think that's too broad? Certainly open to discussion and from the applicant as well as the applicant's professionals. We can use that as a start, but my sense is that there's some folks who think that might be too open at this point.
I'm okay with that. When you use the word tentative, so that means it would be subject to change in the future.
Well, of course,
Possibly.
subject on it to any application, sure.
Okay, so I'm okay with that.
It works for me too.
Was that your LDAT? I couldn't say. I'm sorry.
Yeah, LDAT, it works
Okay.
for me.
Okay. Greg, what's your thought?
Is the line going to be the setback line in green, or is it going to be the pink lines and the setback combined?
Both, yeah, pink and green. Pink
So
and the
the area,
setback line.
so the areas to the left and the right flanking the pink
We're allowed
line,
to
we're saying
whatever we need.
you
to
can't
do.
touch a thing in there?
Do go through this
Correct.
process again.
So they can't even go there and remove a shrub?
That would be the situation at this point, yes. I mean, whatever the rules are with clearing and grading limit
Well,
lines.
I think
have
that's
to come back
before
a
the
little
board.
extreme, but that's just 1 of 5. I can understand limiting an accessory structure to the pink lines, but I would think limiting the clearing and grading line to the pink would be a lot. I mean, you're taking away a lot of their property. Maybe they want to do some trails or some gardens back there. We're saying no. I mean, I don't think gardens are offensive to neighbors. I can understand structures being offensive, and I would fully support limiting the structures in a pink area where, and again, the applicant still hasn't even said they're gonna do it, and we're limiting it, so
Exactly.
I'm against that all. I'm against all of this, but if I have to make a decision, I don't support the pink as the clearing and grading limit lines.
Well, I'd like to point out that when you have, Greg, you talked about, gardens and pathways and walkways. So those improvements actually are not just improvements, it's human activity. And it's the human activity back there behind these people's homes, which I think might be the concern. But you raise a good point. Why not? Then this goes back to an earlier comment. Why not make the setback lines all the way around the clearing and grading limit line? Does that provide sufficient buffer for all of the neighbors?
We don't know, but
We
it
don't
would be a
know.
tentative line anyway.
It's a good start. I think it's a good start. And then when in the future the applicant came back, then I think the clearing and grading limit line does need a harder look, because there could be a clump of trees that we're excluding or a clump of trees that we're including that should or should not be in that line.
But what's the vehicle for the applicant to come back? Why would he come back? Why would he need to come back to us?
Because we have in the resolution, if they want to take down a tree, they have to come back to a board. And if they go back to the environmental review board and they don't feel comfortable with it, I'm assuming they can defer to the planning board.
But the environmental review board is responsible for the environment. They're not necessarily responsible for the
Don't they
neighbors.
review it? So who, if I understand correctly, if somebody wants to take down a clump of trees, they either go to the environmental review board or they come to us. Is that
No,
correct?
they can go to the environmental coordinator or the ERB, and
Oh,
then
I'm
if it's
sorry.
in part of a development, it comes to us.
I mixed
It
up my
rarely comes
acronyms.
to
I
us, actually.
apologize.
And
But
the
there's
certain-
somebody from the town that would give it a look. And I assume that if they felt uncomfortable with the action, this person, the town, could defer to another town board for assistance. Right?
Yeah, but yes, but.
I mean, I'm just trying, these guys just want to do a lot line merger, and I feel like we're burning them down with so much for something that may occur in the future. And they just moved here, and I feel like we're clobbering them. So, I don't know. I feel we're being too tough.
Well, all right, let me change my view. You've raised some good points. I think the pink lines should be called out as the lines with which no structures can be built in addition to the normal setback lines.
Sure.
Structures. I have no problem with the green lines being the tentative clearing and grading limit lines. And, if everything works out fine, then it's going to be fine. It's the key is the structures to me as being the most offensive, which I think, Greg, you noted yourself. And, so I could see that. So now maybe it's 2 to 3.
No, this is Elda. That makes a lot of sense to me. I mean, Greg makes a lot of great points. Certainly, we don't want to overburden the applicant who's not even requesting any actual change to the land. So that makes sense to me. Also, with the caveat that were there to be some changes that went beyond this clearing and grading line or the pink lines, they would be required to come back to us. Is that true?
Yes.
We can draw it up that way. Clinton has told us that we can actually draw up a resolution so we can put those provisions in.
I would agree with that.
Well,
I
that
agree with
seems
that.
fair, balancing the applicant's concerns, the neighbors' concerns, and the town's concerns in general.
Guys, can I say something?
Sure.
Whatever you guys decide is fine. But I think it'd be helpful for us in the future, when we look at this, I would hope it's going to be shown on a plat, not only to articulate it in the resolution, but it's going to be clearly defined on a map. So when we get the map and I review it, we kind of know where they can build the structures and where they can't clear to. So you might want to put that in the resolution to submit a map and show it on the plat map as well.
I
Good.
agree.
Yep.
Whatever you guys want to do though, but at least show it on the map.
Yeah, thank you, Bob.
Yeah, we need to identify what it is we're going to show on the map.
Absolutely.
Okay. Any other comments?
I'm just trying to make sure I'm catching up with any comments from members of the public.
Excellent.
Am I missing any? Does everyone see these?
No,
Does
I
everyone
don't.
get a chance? You don't see these?
Everybody
You need
sees
to
them.
open the
They're
chat
under your
box.
chat bar.
Look under chat.
I think you covered them.
I think so, but I just, it is a public hearing, and I know this is a very difficult way to conduct a public hearing, so I just want to make sure that we're covering the points and responding and letting people have their say.
So just so we understand where we're going, that the setback lines, the green lines, are designated the clearing and grading limit lines, and the applicant is free, subject to our tree and environmental laws, is free to clear that entire area, which is white, right? And could in fact go ahead and just make a lawn in that area behind the adjacent house.
Can I say one thing with the tree permits? There's no mechanism in the tree permit law, chapter 121 tree preservation, that requires Dennis or the ERB to make it come back to the planning board in any way, shape, or form.
Right.
So just as long as everyone understands that.
Ah, well, that's a good clarification. I guess I heard something different earlier.
I just
So I
wanted
guess
to get that on record.
I'm suggesting, subject to those other regulations, that white area back there, the whole thing could be cleared and could be put into lawn, playing fields, et cetera, et cetera, et cetera, should the applicant choose to do so.
Fair enough.
I
think it makes
don't
sense.
have a problem with that actually, but
Okay, I
It's,
just wanted to point out that's
it's-
where we're going.
some of the areas to the left and the right are going to be soupier and maybe difficult to walk on for weeks, on end. Whereas the centerpiece, going all the way back to the north, if you would, to the green, that's 2 feet higher roughly, so it's drier. So I don't really expect that there's going to be a lot of stuff that happens.
Do any of the neighbors wish to speak? We can actually open up your microphone. Apparently, we have the technology to do this. So if anyone is interested in actually speaking rather than the short little typed notes, please let us know, and Carrie can open your microphone and you can speak.
You should have the ability to raise your digital hand and I can open up your microphone.
What's a digital hand look like? This.
There you go. Edward
I've
Phillips
had a digital
here
finger
is-
set to me, but not a hand. But
Okay, I'm going to open up Edward Phillips' microphone. Okay, Edward, we should be able to hear you. Hang on one second, you have to be unmuted. Okay, you're all set.
Can you hear me?
yes.
Oh, it
Yeah.
worked. Okay. I've spoken to Joe and Lauren, and I support any effort they want to undertake with respect to a pool, and we have a great relationship with them. I do have to say though that whether it's Joe or somebody else maybe that lives in the house after Joe, just looking to the future, the idea that the entire white area in lot 7 could someday be just cleared. To me, I have to say that would be, I think, very impactful on the neighborhood. It would definitely be noticeable from Heathcote Drive. It would probably be noticeable from the homes on Cowden, which are a bit up gradient from us. So they actually look down on the woods. So I know that's not Joe's plan, but just leaving the door open like that is troubling to me.
I'm confused. I thought someone had said that there aren't that many trees on the plot, on lot 7.
No, that's not correct. It's entirely
Okay.
wooded.
It's
It's-
entirely wooded.
It's
Well, then-
forested. Yes, I'm
They have
sorry.
to come back for, tree permits before they do any such thing. And we have a project, on the other end of town where somebody clear cut about 20 acres, and they're being required to replant it all, and it's going to cost a fortune.
Yeah, but Dick, that is true. It's also true that we do not, as pointed out by
Bob,
that we do not automatically have the authority to weigh in on that. That it's the environmental review process, which is a separate process, a separate body, and our concerns are not their concerns. Their concerns are not our concerns. I mean, they overlap, but they don't necessarily take into account or are obligated to take into account the sorts of things that we are concerned about. And you could have somebody, not this homeowner, this applicant, but a future homeowner. I mean, I've seen things change in my neighborhood when a new homeowner comes in. I mean, and change dramatically because they have a different vision for the property, and it's their right to have that vision. But I've seen things happen that change the character of the neighborhood. And so I think that there is Mr. Phillips, has a legitimate concern about this. And we would not necessarily have the ability to manage that process because it wouldn't come before us.
Well, so that makes this all very interesting. We may have to vote on it just to see where it goes. But
yeah, it's difficult.
Yeah,
this is a tough one.
This is Sean Jansky, landscape architect. I just wanted to again bring up that there is a pretty robust tree preservation ordinance that describes a regulated landscape buffer zone around the properties, and it requires replacement, trees. And if the green line were to become some kind of a limit of clearing at 50 or 60 feet, that would be 4 times the regulated landscape buffer that's already current in the tree preservation ordinance. So in a way, even without a restriction on clearing and grading, there already are good methods for the town to review any proposed clearing. And we might even be adding more restrictions to that if we do what we're talking about here.
Well, that's a good point, because when we have a project where there is somebody wants to clear trees, they have to plant replacement trees, which then means they would, in essence, put them in the buffer zone, or make what they want to do for a way of an open space reduced. So, I appreciate the comment that we don't want someone to come in and say, oh, I can knock all the trees down. All I have to do is get it by the ERB, which the ERB, if it's a real sturdy, solid forest, they're not going to let it just be plowed down. You can plant elsewhere, and you may end up having to cut the amount of area that you want to open up markedly because it's too expensive to replant everything and then maintain it for 10 years or a minimum of 5 years. So I don't think I'm too worried about the white space, because the total buffer it looks like it's 50 feet on the north side, 50 feet on the south side. That's a lot. And I don't know that the view shed would change. I guess Sean, one might maybe one could take a look at the photography right now and create a picture of what it would look like for the neighbors to see that it doesn't have much impact. We often ask for view sheds, to show what happens. So,
well, I think
delays.
You raised a good point, and I think Tom's point is very good. In that, I think that's one of the reasons why I initially proposed that we don't overburden this property except for the purple lines. But we put language in here that serves as a touchstone for other boards and staff to echo our concerns, so that if there is a tree permit application coming in, that there's something that triggers that review to let them know that we were sensitive to the issue, not just of the size of the tree, the dimension of the tree, the health of the tree, but we were sensitive to the issue that this was a quasi flag lot, and any activities on some of these areas in this white zone could have some impacts, and they should just be cognizant of that as they look at the permit, as well as I said from the get-go, the wetland issue. In case there is a wetland issue, just be cognizant of it. We thought that there might be some issues. We're not saying there aren't, but be cognizant of that if an application comes in the future.
I don't know how you oversee that. I guess you don't. I guess you just trust.
Well, we don't oversee it, but it would be something for the building department. Hopefully that will catch, or the ERB or the conservation board, the zoning board, whoever it might be, will catch.
I agree.
Okay.
It's a very good point, Tom. There's no assurance that it will be caught, and of course they can, just ignore us too.
Well,
if they do ignore us and then we catch it, then we'll have the right to come back and say, based on this document, you did something you weren't supposed to. You didn't follow the sequence, the process, and therefore restore it.
Well, I don't want this to get too rhetorical, and I fear that it is getting there. But it sounds to me like we're asking other agencies to do our work for us. I also think that for many applicants, not everybody, but for many applicants, we know that money's no object, and we've seen that over and over again. And that's not a pejorative. I'm not castigating any of that. I'm just saying that happens to be a fact. So. And then finally, we do have something called a tree bank, and that's used over and over and over again. People making the case, well, I don't want to put the trees, I don't want to plant on my property, or make the argument that I can't plant on my property, and therefore I want to donate money to the tree bank. And I've never been a big fan of the tree bank myself, at least the way in which it's used, but that's something that's available. And I've just brought up 3 different conditions that make it more possible for somebody to come in and clear this white area more than maybe we anticipate.
But then that gets back to the same argument that how can we anticipate everything that could possibly happen?
Well, you can't anticipate everything that happens, but
then you should stick to the bigger things, I would hope.
We regulate what we regulate. That's what we do, right? So we anticipate the things that we regulate might go wrong, and that's why we regulate them. And so that's all I'm suggesting. There is a concern that Mr. Phillips has raised, which is a legitimate one. I actually don't know how to address it, but it's a legitimate one.
But that is why the tree preservation ordinance exists. That's why there's a regulated landscape zone that's 15 feet from the property line. And if the applicant elected not to merge the lots, they could come in with just a tree removal and planting plan without coming before the planning board.
Right. And the tree,
which could have much more of a negative impact the way that you describe it. They could clear with up to 15 feet of that property line instead of 50.
Well, but I don't know. Okay, I think I understand your point, but I'm not concerned about that. I'm concerned about the white area. I mean, that's the concern. I understand. And let's be clear, the tree ordinance is to protect trees. That's all it's supposed to do, is protect trees. And that's what it's for. We're talking about more than protecting trees here.
We have a comment from another member of the public. Carrie, can you turn the microphone on too?
Sure, I just have to unmute.
Sure.
Michael Serglia. Oh, there you go. You can speak.
Good evening. I represent Michael Rodriguez. I had sent you a chat message. I don't know if you got it. He resides at 19 Heathcote. I think the board needs to remember that your predecessors back in 1985 took great care in approving the 8-lot Flynn Capital Corp subdivision, took great care to ensure that this 18.5-acre north-south corridor remained pristine and untouched. And they did so not just for purposes of screening, although that's a very important aspect, to screen the residences on between Cowden and Heathcote, but it's also a biodiverse corridor. And because this 18.5-acre, originally it was labeled Lot 8 on the 1985 subdivision, because it was 18.5 acres and it subsequently got re-subdivided and cut up into smaller lots, I think you're now just focusing on the 2.666 acre parcel behind the applicant's home. And you're ignoring that this is just one part of a larger corridor that's critically both environmentally and for the protection and the aesthetics of my client's home and others that border this corridor. So Mr. Rodriguez certainly approves of the red lines extending the side lot lines of the front parcel where the applicant's home is, and extend those sidelines to the rear of this larger parcel. But to give free hand to the applicant or some future owner of the applicant's property, because once you do this, you do it forever, to give free hand to have any kind of tree cutting or clearing or land disturbance anywhere within the white area on the rear of Lot 7, I think is irresponsible. I think your board will regret that decision for years to come. So we would ask you to rethink leaving the white as a free zone and restrict it within the red lines. And then that's an important aspect to my clients. And because of the location of their septic system, it's going to force them to put a pool basically almost behind the properties to the right and left, of which Mr. Rodriguez is one of them. And also it's going to put their pool in the backyard virtually of the properties on the, I'm sorry, I forgot the name of it, on Cowden Lane.
Yeah.
So that's a problem because of their septic location. The other problem, and I think the chairman points out properly earlier on tonight, that this is essentially a flag lot and carries all of the impacts, the negative impacts of a flag lot. In fact, it's worse. It's kind of like a double flag lot, a T flag lot. So I think the board should not unduly restrict the applicant, but remember what this Lot 7 was part of a larger corridor. And once it got chopped up, it seems like its purpose has been lost over the years since 1985. And we would like to remind the board why your predecessors who sat on the board in 1985 took such great care to preserve 18.5 open acres.
But they, if I could suggest, it looks like they didn't preserve it because it's privately owned land and there are no development. Are there any development? There are, I guess, in their codicils that attach to the property. I'm confused about that. But
Yeah.
there are no restrictions with respect to the subdivisions design within the town. I mean, this whole corridor could have been designated a conservation area. There are lots of things that the original developers and original planning board could have done to actually preserve this property, but it seems like none of those things were done.
Well,
Maybe the intent are not sufficient enough so that they're useful to us in our decision.
That's a great point. This is Eldad. It kind of raises the question, I think was touched on earlier by the landscape architect, that, absent this merger, right, it's just as the tax lots stand today, the Bachkowskis own lot 7. And are there any restrictions? I understand there's the zoning buffer line, but are there any restrictions that would prevent them from clearing this entire property?
Yes. The tree ordinance would prevent that. And the tree ordinance, as someone echoed before, not only would it prevent them from clearing it necessarily without an application, is also a replanting program as well. So there would have to be some sort of reason for clearing the trees, and whatever board would be assigned the jurisdiction for that permit would have to consider whether those were valid. But in addition, there would be a replanting requirement as well.
Or to pay into that fund, strict. Correct?
No. The fund, don't confuse that. The fund is really like a last recourse. I think Tom really, in terms of how we normally deal with this, we really are quite aggressive, and I trust that the other boards and folks who have jurisdiction over this, that's not a simple alternative just to pay instead of replanting. We're quite rigorous in making certain that we try to get the number of DBL replacement required in the code on that site. And it's only if the applicants can show within reason the impossibility or the unsustainability of planting too heavily do they really have the option then to go for the tree bank. Okay, so it's something that there would be a reason why you'd be taking down the trees just per se. Maybe bad health, maybe dangerous, but they would still be required to do some sort of replacement.
Okay, but that's in place today and will be in place tomorrow, subdivision
Correct.
or not?
Yeah, and as things go, they tend to get more intense in the details and harder for people to deal with it. So the rules don't get lighter, they get heavier.
Well, Bob makes a good point. I don't think that we are as rigorous as we could be with this. However, if an applicant makes a point like, well, gee whiz, I need a lawn for my children to play on, and it's my right to do that, and I need to take these trees out in order to do that. I don't, maybe I'm wrong, but it's, I don't know who, if we aren't involved in that conversation, I'm just not entirely sure that the applicant isn't going to be able to get his lawn, for example. I'm not talking about this particular applicant, I'm just talking about in general. And that there will be accommodation for that, which may include not replacing trees on the property, but putting money into the tree bank. And I mean, those things happen, and they do. And I think that needs to be brought into consideration. What I'm about to suggest here is something different, though, because and I remember the first time we saw this, I had gone on Google Earth and I had looked at the property in its context to this broad swath of woods, which are between Cowden Lane and Heathcote, between these two subdivisions, which looked like it was maybe intentional, maybe it was just sort of left over because they couldn't get the geometries right. But nonetheless, it's like, I think it's about 20 acres of woods here. And 20 acres of woods is a significant amount of woodland in our community. And we're looking at this now in isolation of that condition. And there are these other properties that make up this woodland that are going to be coming before us one day, or maybe not, before future boards. And I wonder if maybe we're not looking at this in the proper context. There's so many questions that are being brought up, which are legitimate questions about it. It's hard for me to really understand personally what to do here tonight with it. I wonder if maybe we need to hold this over, and we need to find some way to address the bigger questions that are being asked here.
Well,
the chairman is left.
I do think that one of the things that I didn't learn, but I was reminded in following the last meeting, is that a lot of this area was agricultural. And so it was being used, the woods are actually, there are a lot of trees there, but they're relatively young woods because it was agricultural for a long period of time. And so it was one owner, and then the O'Neills, who owned it prior to Tavalachi, owned it for, I don't know how long, 80 years or so. So it was just one owner that owned this portion of it. But I know that you're saying that it's part of a larger, a larger component.
Well, my take
If I
on this
may,
application- I just wanted to make a couple of comments. My take on this application, this is just myself speaking, but my take on this application is we're making a little bit of light that it's just a ministerial, it's just a lot line change. It's a lot line change, which again has got characteristics of a potential flag lot. And we're not for the kinds of limitations that we're torturing ourselves and the applicant over. I would not be in favor of the lot line merger because we're creating a potential building area in an area that was, I think, was never really designed for this, and an area that if we don't limit it, could impact the neighbors. So that's what it comes down to for me. If we don't have the appropriate limitations, give freedom of development, reasonable access and use of the property to the applicants, but without those kinds of limitations, I would not vote in favor of this lot line merger, and I would keep it as a separate lot. I mean, we have to go back to what this application really is. Do we want to grant a lot line merger? And from my standpoint, is yes, subject to. And that's why I think we're beating ourselves up on this. But the bottom line is, this is not something that we normally see as a lot line merger that creates this potential for a piece of property that looks like and is behaving like a flag lot, or someone mentioned before, a double flag lot. So I mean, we got to move along here and get this, conclude the conversation. But that's where I stand on it.
Could we incorporate language that requires any future applicants to have to come before your board, which would trigger an opportunity for this board to review any impacts to the white area? And right now, honoring the pink and maybe the green as no disturbance at all. But if someone should wish to make an application and review it, that they would be required to come back before the board to go into any of the areas to the north and south. It would give some control back to the board.
Yeah, I personally would be fine with that in terms of, again, as we've spoken before, anything within the purple lines back to the setback line and the rear line, anything to the east and west outside of the purple line, at this point, not knowing what the activity is, I would not agree to it. And I would vote against this application.
So is that what a grading and clearing limit line following those lines does for you?
That is correct.
Right.
Yeah.
So,
Does everyone agree?
I don't think so.
Clinton,
I agree with it.
Let me just.
So it would be a very small T.
Well, I would keep it within purple lines, not the blue lines. Someone drew blue lines on there, I guess.
Oh, those are scribbles.
Okay.
Let me do something. Let me see if I can do this.
Oh, look at that. All lines. So let's make.
All right, listen, we can start over. I'm gonna draw for you what you're talking about, okay?
Go for it, girl.
You are talking about that's your clearing and grading limit line. Straighter, not as crooked, but in general.
What kind of straight?
No, I don't agree with that.
I don't either.
Do you want to? Then why don't you draw your lines? Or I'm sorry, let me wait.
Put your purple lines
Hang on.
back.
Yeah.
Okay, let me do this again. Wait a minute.
Purple lines in.
That's what you're looking at.
Well,
I'm not sure what I'm
That's the
looking
rear
at.
setback.
Right?
Sabrina,
Hang
can I
on, let's do it
Sabrina,
again.
Can I draw something on here so
Yes.
I understand what you did?
Yep,
No.
go ahead.
Should have kept that up there. I was going to work off of that. What happened to it?
Oh, it's okay. I have a better way. Here, we'll go like this. So this is the rear setback line that you're talking about,
Right.
and then this is the western property line.
Right.
Here is the eastern property line.
Sabrina, so you guys want to make this the clearing and grading?
No.
This is the clearing and grading. The white.
Here.
The pink is left alone, but you have to catch the, let me see, part of this is open. This white area, there's a white area down to the south prior, getting right up to the existing lot line. And I think that has to be pink. That we just drew a yellow line, but it has to be, it has to come in and around like this. Yeah, I know you can't see what I'm doing, but.
But you're drawing yellow.
That was
There.
me. I just drew that. I drew
Okay.
the.
You drew that?
Bob,
Yes, Bob, what you just drew in yellow is the limits of clearing and grading
would
and
think.
disturbance.
That's what I
no,
thought.
Yes.
I think it has to be smaller in that you take your yellow line coming down, Bob, and instead of going to the existing property line, make a turn to the left.
On the setback line?
Yeah, on the
On
setback line. Yeah,
Okay.
on
Now,
both
that's going to
sides.
limit a lot of the area. That's going to make.
Yeah.
How far in you want to go, Dick?
Just to follow the, the zoning line, the
Go
35-foot
there.
setback.
And then here.
Then down to here, and then
This
across
is,
here.
this is what they're talking about. Right?
Right.
Is that
Right.
what you're
Yeah.
talking
That's it.
about?
There you go.
That's it.
That's it.
But you got to come back to the property line up here.
Yeah. You can,
He went down a little bit too far. He went into the septic.
I was being
Yeah, but
diagrammatic.
that's the idea, but I don't think you have to have the yellows myself, but I leave that to others.
all right, so I'm with
we would
that.
ask to
Now,
maybe
at
not
this
take that
point, you're
part out.
listening to
This is
everybody's
very, very
views.
bad.
I would say this is a reasonable thing to do, and still we would have the thing, if you're gonna cut down trees, you're gonna have to come and see us. Or see the ERB, and we'll go from there. But that gives some reasonable space, and then if that doesn't, it's a tentative line. It can be questioned later with very good reasons why something else has to happen, or should be allowed to happen.
So right now, in those multiple acres, there are no restrictions, and you're proposing a relatively strict limit of clearing and disturbance.
I think your statement's incorrect. There are severe limitations. You can't do anything on that lot in terms of building a structure. It's not a building lot.
Well, we're
So
not
you can't
looking
do
to,
anything.
we're not looking to circumvent that. It just sounds like you want to sort of highlight multiple acres as sort of extra review or extra restriction beyond the tree preservation.
Correct.
Yes,
Yes.
yes, correct. Yes,
So
absolutely.
Because otherwise it looks like you're trying to do development behind someone else's house. It's not fair.
And again, the applicant could choose to not merge the lots and simply submit a tree plan without this 3 or it's hard to figure out how many acres this is. 2 acres of
2.66.
No, I'm trying to figure out how much area you're basically
It looks like, to me, it looks like maybe it's,
acre and a half.
no, probably an acre. If the bottom existing lot is an acre, then this other one is close to
3/4
or less.
Yeah.
Unless I'm mistaken, yes, you could do that. It might be the rational thing to do in this eventuality, but I think that the consequences of that might be if that lot line is not removed, joining the two lots, then you're dealing with a setback line all the way across that lot line. And if you want to put certain improvements that otherwise would be not allowed within that setback, you would have to go before the ZBA, I think, in order to get their approval. And that would be another step in the process, and you would make your argument to them. You understand what I was trying to point out?
I don't see how that works. But,
how what works?
well, you're saying if the lot line approval does not go forward, then they, because they own the property, can go in and do something else. But it's going to be a very small window then, because they have 50 feet here. At the bottom of this T, the small T, you chop off the bottom of the stem of the T.
Right.
And
that's a setback.
You can't build on it. I don't see how you build on it with keeping the 50-foot front and backyard things.
Well, exactly. I guess. I mean, I don't know what the proposals are to build. Maybe you can, maybe you can't. But that's the consequence. That would be the consequence.
I think we have,
of not getting rid of the lot line, I think.
Yep. I think we have a question also from a member of the public again. Carrie, can you, if Mr. Siriano wants to speak again, could you hook him up?
Yes, his mic is open.
Okay.
Yes, I just want the board to note that Sabrina gave you a memo dated November 30th of 2016, when the developer was seeking to do pretty much the same lot line. And in paragraph 8 of her memo, she's, I quote, per the previous resolutions, deed restrictions / covenants were to be filed regarding the provision that no structures were permitted on lot 8. I think that's a correct interpretation of the resolutions that created the original lot 8.
But this is lot 7.
Well, it's 7 now, which was part of the larger lot 8, the 18.5 acre lot 8 on the 1985 Flynn Capital Corp subdivision. So I think one of the members had previously commented that there is no prohibition on structures, but in fact there are. The other thing
and that was.
Yes, go ahead.
I would just like to say that question came up at our last meeting, and council was looking into that specific issue, because it was raised in my memo back in 2016, and it came up again as part of this application. So I just wanted to put that on the record.
I understand, and I agree with Clinton Smith's advice to you that it's not the planning board's job to enforce private covenants of which the town or the planning board is not a party or is not privy to. However, which means that the only thing the board should be focusing on is the limits of disturbance of what can happen on this lot 7 once you approve a merger. And by the way, the applicant doesn't need a merger if he wants to put a pool on lot 7. He can go to the zoning board and ask for a variance for an accessory structure on a lot that has no principal structure, has no residence on it. And then it's up to the zoning board, who are experts in balancing the equities and the rights and privacies of neighbors with an applicant's wish for development. So it's not as if you have to grant this lot line change without imposing reasonable restrictions. And I believe the yellow line, it's the color it shows up on my screen, is a reasonable area for a limit of disturbance. Thank you.
Thank you. Any, Greg, Eldad, any thoughts on the current lines up here? I guess the colored lines.
This is Eldad. I mean, it seems, from my perspective, too restrictive and I'm not really sure, we've kind of swayed over the course of this conversation back and forth. And I'm not really sure what pushed us one way or the other. To me, this is too restrictive. Again, the request is for the elimination of the tax lot line. And so in exchange for that, we're placing additional restrictions. I understand how there might be sort of a give and take here, but it seems to me that the restrictions in place are sufficient. Adding an additional clearing grading limit line here, as is currently shown, seems like it's too much for me. There is the 50, I believe that's a 50-foot buffer, with adjacent to each neighbor, and that's significant. I mean, this back parcel, this lot 7, is quite big in and of itself, right? It's the size of essentially like a New York City block, like 200 by almost 600, and so the buffers all around it are significant. I don't know how the rest of the board feels. To me, it's a little bit too restrictive from my perspective. I understand the neighbors' concerns. I think that they would be, there is no structure permitted outside what were originally the pink lines, right?
Those are our lines. Yeah.
Yeah, no, all right, but I think that's something that we're all supportive of, I believe, and so it's really what we're asking. The question is clearing and really the question of trees beyond what is this yellow-orange line to where the green zoning setback line is.
Eldad, the lines that I think you are saying are buffer lines, those are rear yard setback lines. They aren't landscape buffer lines.
Right, zoning setback lines.
Right, so inside that line, you can go ahead, unless there are further restrictions, you can pretty much go ahead and clear. And I think that's why we're drawing this yellow line. And maybe I think you're saying the yellow line's way too restrictive, but the that dashed line is right now not a, as the code exists, is not a clearing and grading limit line. They can clear beyond that, so it's not a buffer line.
Yeah,
right.
Okay. I understand your position, and it is restrictive, but I'm not going to use the word tentative because we would put it in the resolution and put it on the plat. But it is, of course, subject to a permit from the applicant at any time in the future, or future applicants, future owners. And then, of course, that would be considered by the board, and different strategies could be looked at in terms of what it is that might be the application. So I think it's, I certainly understand your position, and I was swayed at one point that it was a little bit too tight, but really, I think to open it up broadly without having a relook at this, if an application is ever filed, is what persuades me to think that these are appropriate lines.
We have I agree, Bob, and we have an obligation beyond, as we all know, beyond this particular property. We have an obligation to the adjacent property owners. We have an obligation to the neighborhood. We have an obligation to the town. And one of the things that Clinton pointed out was that technically his interpretation legally is that this is not a re-subdivision. That may be true, and I'm not going to dispute that. But in essence, it actually is. In effect, it actually is. And it begins to lead, because it changes the size and configuration of a piece of property within a subdivision. It's a re-subdivision. And what it does is it changes the character of the neighborhood as a result of this. And it sort of opens the door to re-subdivision further down the road, literally down Heathcote Drive, for the property owners who have a like condition. And I wonder if we are opening the door to a subdivision plan that in effect happens over time, that we wouldn't necessarily support if we were to look at it and to take it all in as a consequence of the action we're making today. And so that's why I'm sort of concerned about doing this in isolation, because I believe it is opening the door to a further re-subdivision of this subdivision.
Well,
And the consequences of that is something that we, maybe should be concerned about. If we're saying that this yellow-orange line here is where we're willing to go today, I'm comfortable with that. But beyond that, I think that we ought to hold off and look at it in a larger context.
I think I agree with that. I certainly think that with the 50-foot buffer on the top of the yellow brick line there, 50 feet, and I assume there's another 50 feet on the other side, that's 100 feet of forest that should buffer anyone's view from a road. And similarly, you have another 50 foot, on most of the rest of the property. So I don't think the impact on the view shed of other neighbors is going to be that noticeable. And if you have a 100-foot buffer, that's certainly a great corridor for animals to go back and forth. So I think for environmentally, that's probably okay. But I think that this is the size that we should be going forward at this point in time. And as the chairman said, if somebody wants to submit an application to try and change it, well, then we can all sit down and discuss it and see what the plans are. So I think we should go with this.
Richard, can I say one thing? That actually front yard setback between the two properties, that's actually 60 feet. So you got 60 feet and 50 feet. 60 feet and 50 feet. Well, you have, okay, on the south side, you have 60. Is that what you're saying? On the east side, you have 60 right there. Right where
Where's the arrow? Oh, there's the north arrow over here. So the east side, yes, 60 feet. I see the arrow. 60 and 50. The name is covering up the arrow. My goodness.
Well, I think that's an interesting point. I think it also supports Tom's observation that it actually operates as a re-subdivision because we're using, setbacks for a front yard setback for that rear lot. Mm-hmm. Again, look, we're not going to call it a flag lot, but boy, it sure looks and smells like one.
Well, but the part we're working with is not a flag lot. It's just an extension.
Correct. Greg, where are you on this?
Just if I could make one comment, given that it is just an extension, would it be fair to go back to the purple lines that are just straight back from the front lot as opposed to making that little T?
Well, the issue there is that these are setbacks already, zoning setbacks. So I don't really have a problem with it, but it is a zoning setback. So maybe that is an issue. Again, if it's something that you have an application, we could certainly look at, and perhaps the zoning board would have to get involved.
Well, I have a problem with it in that I like the way this is set up because for the owners of property on either side, it's more of a buffer into whatever might occur there, even if it's just mowing the grass and making, a place to run around and kick a soccer ball.
But this area,
I don't really want to change this.
Those areas that are shown here allow for additional screening if we needed it.
So to answer,
well, yeah, but that's why I want to have it that way, so that it's the only place you can open it up is within the the T, the shrunken T that we have now.
Well, I'm not sure about this because in any other plan that we, people improving their property, putting in swimming pools, et cetera, et cetera, et cetera, we what is this? It's actually it's a 35-foot side yard we're using as the clearing and grading limit line, as the buffer line. That seems pretty excessive. We don't usually require that much for conditions like this. Usually it's like 10 or 15 feet. And I wonder if we aren't just taking a line that happens to be on the drawing and say, well, let's just use that one, which, just doesn't make that much sense to me. Maybe we ought to go back to what would normally be our dimensions here.
I don't think we have to do that. I think that it should be extraordinary. And that doesn't preclude that they can't come back and ask for something that's more. But why give more now?
But that area is not buffering. It's really not buffering anything, really. I mean, so I don't get it.
This area back here, the 35 foot in the rear?
It's not abutting a property line. That's not abutting a property line.
Oh, you mean those squares?
Yes.
Yeah.
Oh, okay. Yeah, I'm good either way.
I'd like to bring those lines back. I'd like to extend the property lines back if we're going to delineate this area.
I would agree with that.
Opens this up to us to supplement with
I say that, I
landscaping.
know we're making some progress, as I do think Ed Phillips and the Rodriguezes were both in agreement. The neighbors were
Yeah,
both in agreement
I
with those
agree.
lines.
Yeah,
So,
I'm okay with that. I think that's fair.
Back to Sabrina's purple lines.
The purple lines, yeah,
Yes.
that was, yeah,
I agree.
the peach.
I agree with
The
that.
peach one. Yeah,
Is the applicant
Okay.
okay with this?
Well, to be clear, is that a,
Because I never got to say what I wanted to say.
yeah, well, yeah, you got the
I-
floor.
Again,
I would support this as long as when the applicant comes back with a real plan, and if they discover that they've got area here that they cannot build in for whatever environmental reason, that they should have the right to maybe revisit expanding the line so they could use their property.
They always have that right.
Can,
Then I
It
would,
was the
support-
application.
then I'll support this.
Yes, if we have that right, that's acceptable.
Well, it's a right to file an application. I mean,
Mhm.
so you always have that right.
Good.
just plan enough time for talking and everything.
so you'd be restricting any proposed accessory structure to within that orange rectangle?
Yes.
Correct.
correct.
And
Any activity,
any
any
act-
activity.
Any activity, yeah.
So-
Any earth moving disturbance.
And
Right.
any land development activity, right?
So that's a
Right.
vegetable garden.
you would not be restricting it outside of that rectangle, you would just be requiring a planning board review of it as a regulated activity.
It would require an application for anything outside of that rectangle.
Okay, it would not be
And a review.
restricted.
Pardon?
It wouldn't be prohibited, it would be regulated. It would require an application and a review
Correct.
and approval by
Correct.
the planning board.
Right.
I hope that this conclusion, actually, we were here a long time ago, but it was important to talk all this through. I think there are bigger issues for the larger subdivision, but that's not the subject for tonight. That this conclusion allows the applicant to move forward with foreseeable improvements that they're anticipating. And the applicant should understand, as we just said, that there is nothing that prevents you from coming back and saying, well, now I want to do something beyond these lines, and I'm going to file an application for that, and potentially get the approval to do that as well. I hope that this gives you a chance to go ahead and move forward with what you want to do.
Yeah, I think this
If
is.
I may suggest some, go ahead.
Go ahead, Sabrina. Sorry.
I was just going to say, I did edit the resolution as you were speaking, and if you'd like me to go through those changes, I am happy to do that.
Well, what I think we should do, I think we have, well, maybe we should take a vote on this, but I think we have a sense of the majority of the board for this. I would like to see the language so we can just put this over for the adoption of the final language of the resolution for the next time. I mean, it's going to be approved, but just make sure we get the language straight. Does that make sense? Because
Well, I would ask to do more than, just the language, Bob. I would ask that we get a plan that has this line drawn
Correct.
on it.
Yeah, I think that Bob asked for that. I think that that's important. I agree with Bob and Sabrina.
Yeah, I said a while back, right? Makes sense. You
Okay.
need the map. It's nice in a resolution, but if you don't have a good map to look at for enforcement, it gets difficult.
Could it be a condition of the final plat to include that line?
Sure. Similar ones have done that way. It's up to the board, but they've done them that way in the past.
I think that if you could just give us a map with the line on it, I think we could condition the plat to be surveyed and put on there as part
Yes.
of a condition. Bob,
Okay.
do you agree with that?
Yeah, it doesn't have to be surveyed. It's just the mathematical line you're drawing on it from the property lines, but it should be
Right.
shown on the plat nonetheless.
Yeah. I agree with
So
that.
we could turn it into a two-phase, just something that shows the line other than what's on the screen now on a map, and then we can condition it to be formalized.
Right, then I review the plat, I'll make certain it's on there.
Okay.
Right,
Another
and then we
comment?
can send around a marked up resolution.
Okay. And we have another comment from Mr. Siriano. Carrie, if you could set his mic up. Are we set? Do we?
Hang on, oh, there he is.
Oh,
Okay.
Okay.
Yeah, I withdraw my comment or request to talk. I think you've reached a fair compromise.
Okay. Very good. I'll ask if there are any other comments from the public. I guess I'll give you a few moments. I see that Mr. Phillips is okay with these yellow lines and happy to work with Joe on anything else he needs. So is there a motion then to close the public hearing?
So moved.
Second,
Second.
all in favor?
Aye.
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 Any opposed? Okay, motion's carried. Is there a motion to instruct staff to rework the resolution based on the conversations we've had this evening and then have it ready for approval at our next meeting so that the applicant can be done and finished? By the way, Clinton, do we have to at this point waive jurisdiction if we're so inclined? Is this the time that we would do that? Of course, I don't know why we're waiving jurisdiction if we want to keep jurisdiction forever on this.
When you waive jurisdiction, that is for what purpose?
Normally, it's to speed things up and not go through a public hearing.
You've just had a public hearing, so
We
for
pretty much exhausted that one.
yeah, so no, you don't need to deny. You can do it in the resolution.
Okay. Okay, not so sure we will anyway, so we'll see what the resolution says and we'll work with it. And again, we'll try to get the draft resolution to the applicant for their review. We do not want to impose something that they feel is completely unfair and irresponsible. So we always work with applicants on these. Okay. And so we'll see. When do we meet again? June
17th.
17th. Okay.
Yeah, right.
No need to attend if you, unless you really are gluttons for punishment, but we should be able to handle the resolution without much controversy, and we're done in terms of the public conversation. Okay.
Okay.
Great. Thank you. Sorry
Thank
for
you
the
very
length of
much.
the discussion, but I thought it was worthwhile. Okay, we move now to our next item. This is a request for an extension of approval, 767 King Street, LLC, Chislehurst subdivision lot number 6. No, it's not Citron. A request for an extension approval, site development plan, 767 King Street. Any issues, problems with this particular extension request?
Mr. Chairman,
Yes, sir.
I'm leaving. You're
lucky.
Me.
Do
I'm
you want a
turning
motion?
over- Pardon
You
me?
can't leave without a motion.
Jennifer, where are you?
The tag team.
Please let him go.
Bye, Clinton.
So long, everyone.
Hi, Clinton.
Good evening.
Thank you.
Thank you.
Good night.
Good evening, Jennifer.
Hi, how are you?
Okay.
Tired.
It's been quite a night.
Yes. Bob, Sabrina, anyone, any objections, problems with the request for the extension on 767 King Street?
I
don't have any.
Nope.
Okay. Is there a motion to grant the extension that the applicant has requested?
Motion.
Second?
Second.
All in favor?
Aye.
Aye.
Aye. Any opposed? Not hearing any, motion's carried. We have another extension. This is the extension for Citron, which I believe is on Westwood Drive. This is the development, I think it's steep slopes and trees. I don't know what else was involved. It's a late entry, but I think Sabrina sent around the letter, or Alicia sent around the letter for the extension. And again, are there
Alicia
any
did.
problems from the standpoint of the staff?
I have
No.
question.
No, still just
We-
progressing
just out of
along on this?
Just out of curiosity, do we know, it seems like these guys roll in every 3 months and ask for an extension. Do we know what's going on with this project? I mean, they didn't even, in your letter, they didn't even say why. They just said we need an extension.
Yeah,
Is
for a
that
year.
Citron? Is that Citron?
Yeah.
Yeah, for a
Yes.
year.
Yeah, well, I mean, from my level, they were submitting some things as far as what was needed for the planning board, but then it just kind of leveled off a bit, and I haven't been getting much information of late.
Okay.
You know, as far as the
Sure.
planning board resolution conditions.
I mean, we always have the option to deny the extension, but be prepared to have to reopen the application and look at this again.
Oh, I'm not looking to deny. I was just asking if we knew why they keep delaying.
And no additional pay, by the way.
Well, I would suggest that we go ahead with this, but if they're gonna come back in a year and say they need another year, then we have to seriously look at what's going on, or have there been rule changes that we want to, go back in and look at? And that would be the way I would handle it.
Sounds
You don't
reasonable.
have to issue. You don't have to issue it for a year. You can grant it for 6 months, 8 months, however you feel, and then have them come back and give you, kind of an update.
How long has it been?
Oh my goodness, 2-3 years.
Yeah, this
Well,
is
maybe,
the 10th
maybe it's
extension.
time. I mean, I don't know, but what's changed in 2 or 3 years? Are there any conditions that we need to look at again?
What I can do for the board, I mean, I keep track of all the planning board resolution conditions that they submit. I'll put down today's date and keep track of what items have been submitted from here till the next time they come in, and let you guys know what they've done.
And I
That'd
think
give
6
you-
months might be appropriate so that we have.
Bob, can you step closer to your phone? You're hard to hear.
Oh,
sorry.
you always say that, Sabrina. No, I can keep track of the.
Not
condition-
you,
Other
Bob.
The other
Bob
Bob.
Kirkwood.
Oh, I'm
You're
sorry.
okay, Mr. Scioli.
I'm losing my mind.
Okay. So we'll try a 6-month extension. Does that sound fair? And
Sure.
Bob will give us an update in terms of what they've done in those next 6 months.
I like that. That works.
Okay.
That works.
Okay. So is there a motion to grant the extension of 6 months to this application? When this
Motion.
Second?
Second?
All in favor?
Aye.
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 Any
Who
opposed?
first said the
Made the
motion? Yeah, made the motion.
Eldad.
And I'm sorry, let me just interject for 1 second. So 6 months, they're asking for a 90-day extension for the plat filing, and then a 1-year extension for the steep slopes, and a 1 year for the wetlands and tree permit. So if we do 6 months across the board, then essentially we're giving them more than they're asking for on the plat. Right?
Point.
Yeah.
So
So
we
do you want to do
90
90 days
plus-
on the plat and 6 months for everything else?
Right.
Yeah. Nice picture.
Sure. If
That
you think that's
works.
appropriate, we can do that.
Okay, yes.
Okay. Yes. So that was the revised motion and the revised second, and the revised vote is all in favor?
Aye.
Aye.
Any
Aye.
opposed? Okay. None. We're all set. The motion's approved. And minutes from April 21, 2020.
Mr. Kirkwood, you're still hard to hear.
There's something wrong with your mic.
Yeah, it's probably could be the battery's going. I have very limited batteries for my life around here. But I'll try to speak louder. Any issues, questions on the minutes of April 21?
Well, I submitted one comment and the 2 typos. Felicia, did you get those?
I did.
Okay, and they incorporated. There's one we should probably discuss, and that's on page 6. And it's line 7. And the sentence says, "It is very important to follow the recommendation of the DPW commissioner, who is in favor of looping the water main." I think it's very important to consider it, not to follow it.
Good change.
Okay?
Yep.
Because you can see why.
Anyone else, anything? If not, is there a motion to approve the minutes of April 21?
So moved.
Second,
Second.
all in favor?
Aye.
Aye.
Aye. Opposed? No, okay. Sabrina, as threatened, is Nick gonna get on the wire here? Apparently.
Nick is on.
Well, Bob, I'm here and I'm enjoying your
Nick
voice.
is
Very
on.
robotic.
As threatened. So we have a special guest here tonight. Tonight's law change from the town board. Nick, maybe you can let us know what's going on.
Absolutely. Thank you, Bob. So tonight the town board introduced a local law and referred it to the county and the planning board and set a public hearing for June 16th. The intent of the local law is to suspend zoning laws so as to permit outdoor business area permits to be issued by the town building inspector for outdoor uses of public and private areas to allow retail businesses, gyms, restaurants, and professional services, personal services like haircuts and nail salons, to have increased their retail space in light of COVID-19. And to do this, on public spaces, the municipality has the ability to decide how it wants to use its property. It does have a sidewalk cafe law, but that only applies to restaurants, not to the other 3 uses, gyms, retail, and personal services. But there's also the potential for businesses to want to relocate some of their indoor activities to outdoors on private property. And the local law envisions that for a period until November 15th, which will likely be sooner because it will be dictated by the weather, zoning would be suspended and site plan review, things of that nature would be suspended. And this is only temporary, and it would allow for the building inspector to issue outdoor permits for such uses. That's really the intent of the local law, and we're going to send you a copy of it. It's been an issue that we've wrestled with. We were hoping the governor would have issued an executive order, or the county executive might have. If the town supervisor were to issue an executive order suspending the law, it would have to be renewed every 5 days. It would require New York State Department of Health approval. So that's why you're getting it somewhat on the fly now. We're requesting that you hold a special meeting before June 16th to review this local law so that it could be adopted on the 16th in time for restaurants who open up in phase 3 to really hit the ground running. And the town board did adopt a resolution tonight authorizing the town administrator to issue permits on public property in the interim until this law is adopted, but that doesn't address private property situations. Also, some of the difficulty is that we really can't envision until we get applications, how do these businesses plan to use public property or private property? And what we're doing, of course, is making sure the public safety concerns are addressed, safety of pedestrians, ADA access on the sidewalks, dangers from any vehicular movements, as well as coming up with a plan that is equitable. But we're balancing those concerns with making sure that we use public safety concerns to allow these stores and businesses to open up and move some of their uses outside to reduce COVID-19 risk. So we'll be sending you a local law, and Bob, we would appreciate if the board could schedule a special meeting to review just that local law prior to the 16th of June.
Okay. Obviously, we'll have to do it remotely, I'm sure we'll be still working remotely at that point. So we meet on the 17th, which is a day too late. So you want, what's the normal lead time that you need on that would, preparing a memo?
Well, the question is, Nick, when are you circulating the law? Have you done it?
No, I was waiting till the meeting. I didn't want to email until we spoke to the board. But now that it's being introduced.
So,
oh yeah, we have it drafted, so we'll send it tonight or tomorrow morning.
okay, so then the board will, we have a couple weeks. Do you want it for a week and then we can talk and draw up a memo for the chair's signature? Or do you need, how much time do you need to review it?
What's everyone's calendar and schedule look like? Do you want to, Sabrina, what's your schedule look like? I mean, we'll do it obviously remotely.
We'd have to do it remotely. Listen, I am usually on town board meetings as well. So Tuesdays is not necessarily a good meeting for both Bob and I, as we're called to serve that board as well. Right. However, if you want to, we have to notice the meeting, which we can do within, a week. So if you want to set a meeting the week, next week, maybe next Thursday.
Remember, you're not tied to evenings either. It can be during the day if that works for other people. Tuesday and Thursday of next week, I do have other meetings. If
in the evening.
Matters. In the evening, yeah, I have other planning board meetings.
And this is subject to being a regular public webinar, a public meeting. So.
Okay. Preferences, board members, during the day and evening? You want to do a Wednesday, the 10th, 9th, 10th, 11th during the day? In the evening, we could do it earlier in the evening. We don't have to do it at 7 o'clock. We could do it earlier, 6 o'clock.
I'm pretty flexible those days.
5 o'clock.
Yeah. Okay. 5 o'clock.
5's okay with me.
And this would be the only matter, right?
Yes. Yes, sir.
Yes.
If it was at 5 o'clock, I could do Thursday.
Okay.
If Thursday works for everybody.
It's okay with me.
I'm good.
It's okay with me.
Okay. Thursday the 11th at 5 o'clock.
That works.
Right. Tuesday.
Is it okay? Let me ask before we continue. I'd like to ask NCCTV if they have any conflicts with doing a webinar at that time on Wednesday.
Right.
Or on Thursday or Wednesday?
Thursday the 11th.
Or Thursday. Sorry.
The 11th.
It should be fine. I have the fire commissioners at 7, but do you think it'll be more than 2 hours?
No. Oh, it better not be.
Based on tonight's performance, could be.
I can arrange to hand it off if necessary.
Okay.
Hey, Nick, I have a,
yes.
this is not going to be dispositive or anything, but I'm just curious, in this category of personal services, is there any anticipation of, I mean, I've traveled in India and the Middle East and the Far East where a sidewalk barber is literally a sidewalk barber. Is there anticipation that you will have barber chairs in the outdoors in the public realm, or is that actually something that's happening elsewhere in the country? Do you have any background on this?
Well, I seem to be, as I'm getting older, I'm getting less and less haircuts on my background. So not as informed as it used to be. But I have not heard of it. We haven't seen it. But in drafting the local law, we thought nail salons, barbers, they might want to do that, and it would provide a different experience. So we're trying to think outside the box and be as proactive as possible and envisioning that as long as the conditions are met, and of course, to be subject to health department allowing it to occur. Because there may be restrictions, but yes, that's the idea. Absolutely.
We've actually, one of the first requests that I received in another community was for exactly that, for an outdoor barber and an outdoor hair salon. And that's what sparked in that community this thought process for allowing through administrative permit this outdoor business area, not necessarily restricted to restaurants, but to other types of businesses as well. But it was a hair salon and a barber. That was the first request that came in another community.
Huh.
So I presume the law is going to set forth dimensions and where you can do it, and still, easement or access on sidewalks, et cetera, and all those kinds of things?
Well, the law doesn't, because not one size won't fit all. And there may be, for example, a retail store shuts down at 5 o'clock. They no longer have the need to use their space outside the store. So a restaurant might be able to temporarily put chairs there from 5 to 7. We're really trying to make this as little red tape as possible and vest the building inspector with a lot of authority to use the space. There's also be questions: how do you come up with equitable allocation? What if somebody wants to use a public space that is away from their business? How do you give priority over that to people? So there's a lot to be worked out, and we figured if we did a code, the pandemic may be over by that point. So we want to vest authority with the building inspector, and the building inspector has to coordinate with the town staff, the police, the engineer, planner, fire department, and that's how we're trying to address it.
Nick, a question for you. I'm dealing with this at 2 other municipalities right now, and one of the things they're wrestling with is open container.
Right.
So people could be like at one restaurant and walk over to another restaurant. Is that being discussed too?
It's not to the extent of, we're hoping the SLA will address that issue through an executive order, because the SLA license they receive would have to be modified to allow service of alcohol outside and off premises.
Right.
And that's going to be the issue. So that's beyond our control, and that's something we're going to have to also enforce.
Will this be in Millwood and Chappaqua? Will this be Millwood and Chappaqua, or just Chappaqua?
No, the entire town. So Millwood and Chappaqua.
Everywhere.
Okay.
Yes.
We could have an extensive Chappaqua crawl.
Oh, we lost Nick.
Okay.
No. I got a little notes. My battery was dying.
Yep. Okay. Well, we'll look forward to the law.
Yeah,
and then we'll meet then
Sabrina,
on June 11th.
I sent you great. Sabrina and Jennifer, I sent you the law. If you could
I
forward
saw
it, just great.
It will
Thank
be
you,
forwarded
everybody.
first thing tomorrow.
Great. Thanks, Nick.
Thanks, Nick.
Okay.
Anyone
Good night.
else? Anything?
Thank you, Nick.
Yep.
Thank you, Sabrina. I know you sent over the code information on the scope. I don't know if there's any question or comment on that. The scope about the downtown.
Yep.
So thank you.
Yep.
Thank you for forwarding that. Any thoughts, questions on that, by
Sure.
the way? If not, I don't need to extend the meeting any longer.
Yeah, no record tonight.
Yeah.
No. Oh, that was a record, the first one.
It's just like old times.
Anyway, good. Is there a motion then to close tonight's meeting?
Motion to close tonight's meeting.
Okay, second?
Second.
All in favor?
Aye.
Aye. No opposition? Okay, we're all set. We'll see you in a week or so.
Good night.